Hello, everyone. This is the lecture for Chapter 5, Will Preparation and Drafting. I just want you to keep in mind that obviously I'm not going to go through and read the book to you because you have questions on those, but I'm going to highlight some of the specifics. The first thing I want to talk about is how important it is to be professional and sensitive, even more so in the area of law of estate planning. Will preparation and drafting can be very difficult for clients, and so it's very important to have a good demeanor with them. When you when the client is being interviewed, basically the proper planning and drafting only can occur if we have accurate information. So that's the first thing we want to make sure that we get is all of the information accurately. And you could have a great document, it could be perfect, but if it doesn't really, if it's not accurate, it doesn't do anything, right? So it's crucial to make sure that you get everything in this client interview. Checklists, information gathering sheets, those things are very helpful and recommended for sure. A lot of law firms will have their own already prepared as you have been doing your will drafting assignments. One of the things that you were asked to do was prepare some kind of information sheet. One thing that you want to keep in mind is being a good listener and showing empathy is very important in this stage. Gaining the trust of your client, making them feel comfortable. This is obviously going to be a difficult thing for them. Nobody likes to think about it, but you want them to leave feeling like they did the right thing, they did a good thing, even though it not always feels the best to talk about when you pass. So one of the things that is in a will is usually an exordium clause, which contains certain information. Now, this doesn't mean that all this specific information has to be in one clause and has to be labeled exordium clause, but it's a lot easier if it is all together. So, for example, you need to have the testator identified, right, by their full and correct name. You need to know where they're domiciled, and so you can see this is city and county of. That the testator is sound of mind and not under duress or undue influence. They need to know the nature and extent of the bounty, and they need to declare that the current document is the actual will of the testator, and they revoke any prior wills made by that person. So these are things that are usually found in an exordium clause. Some of them can be maybe separate as a preface or found elsewhere in the document, but it really helps for it to be contained in the exordium clause. An apportionment clause basically is telling they're telling the executor how to apportion the debts and charges of the state. This could be liens, taxes, funeral expenses, or ancillary administration, meaning, hey, we have property in this other state, and now we have to get jurisdiction to go ahead and transfer that to the beneficiary. You're going to need to do that in the state where the property is located if it's real estate. So that's what we consider ancillary administration, and there may be a charge for that. Dispositive provisions basically are provisions that say, hey, what happens if I have a named beneficiary, right? I bequeath something and or my residuary, and what if the person has already died prior to the testator, the person making the will? What then happens to it? How do you want to divide that? Does it go to their heirs? Does it go to the residuary? How do you want it to be handled? So that's called a dispositive provision. We will see a personal representative that is designated. One of the things is going to be whether or not a bond is required by law, and whether there should be a surety for that bond. The personal, then it's going to talk about the roles of the personal representative, and they can usually be quite lengthy in that their authority. There is something called an interorum clause is what it is, interorum clause. And what that is um, a clause that says, hey, I am giving you, you're a devisee or legatee of me, and I'm giving you something, but you cannot dispute the provisions of the will, or you are now out of the will. They're basically used to discourage challenges to a will, and so that the will doesn't end up in a long probate. And the way they discourage it is by basically revoking a beneficiary's inheritance. Um, these clauses are generally enforceable in most states, can be disfavored and subject to strict construction. How far we actually enforce and limit them differs between states. In Kansas, they are valid and enforceable against the beneficiary unless the beneficiary had probable cause to challenge the provisions in the will. And that obviously would be a fact-based determination. A testimonium clause is basically saying that I am executing this will as this testator, and I'm doing it willingly and in the presence of witnesses. That's the testimonium clause. And then we have the attestation clause, and that is where we have the witnesses sign that they have um, witnessed this in the presence of the testator and of each other. And then finally, the self-proof affidavit, which allows us to be able to take our go through probate without having the testimony of the witnesses who actually were there witnessing the testator. This is not included in every will. Very, very, very highly recommended that there is a self-proof affidavit, a testamentary affidavit. So what I would like you to do for this assignment is locate the last will and testament of Frank Sinatra. It's at the bottom of page 423 and 429 in your book, and answer the following questions that I have here. I have also attached them in a Word document for you. If you have any questions or concerns, please feel free to contact me.